Join us on the Jess Get Hired podcast as we unveil the loopholes and myths about at-will employment. I'm Vicky Brown, founder and CEO of Idomeneo, an HR consulting firm. Get ready to uncover the reality of at-will employment and your role in the process. This is an episode you won't want to miss.
Hi, everyone. This is Greg Brooks with Rocket Station.
You're listening to the Jess Get Hired Podcast.
Hi, Jess Get Hired Podcast fans. This is Rebecca Lee Doran.
Hi, I'm George Murray, author of the book Hired, Cut Your Career Search Time in Half.
You're listening to the Jess Get Hired Podcast. Make sure that you like the podcast and share it with all your friends. I can't wait to hear what you think.
Hey, everyone, and welcome to the Jess Get Hired Podcast. I want to welcome you into episode 59 of the Jess Get Hired Podcast. I'm your host, Jessica Fiesta George. This is the ultimate destination for career enthusiasts like you. Well, if you're a seasoned professional or just embarking on your career journey, this podcast has you covered. This show is your compass through the dynamic world of careers because we offer invaluable insights and a lot of guidance. I try to help you explore all things career related, from insider tips and strategies to help elevate your job search and secure that coveted promotion, to nurturing your personal and professional growth. And not only that, I am on a mission to help business leaders find, retain, and nurture top-tier talent so that their organizations will thrive. But there's more. I cannot do this alone. So from time to time, I like to bring in industry disruptors, those visionaries and innovators, to help lead us through these conversations. Well, if you're new to the show, maybe you've been around for a while. Hey, everyone. My name is Jessica Fiesta George, and I have nearly 2 decades of experience in the talent industry. My mission with every episode is to deliver the knowledge that you need so that you can excel in the art of talent acquisition. Well, today we're about to embark on an eye-opening journey into the often misunderstood world of employment law. So our episode today, we're going to talk about at-will employment, and we're going to talk about the legal loopholes and all of the different labor myths. And you might be wondering, what's the deal with at-will employment? You've probably heard that before at some time in your workplace, but do you really know what it means and how it impacts you if you're an employer or an employee? Well, you're in for a treat because today I feel like we're just going to scratch the surface. We're going to dive deep and try to debunk the myths and unveil the truths behind at-will employment. And of course, I have someone who is an expert on this because I know I'm not. And I'm joined today by Vicky Brown. She is the CEO and founder of Idomeneo Enterprises. She's a seasoned HR pro with over 20 years of experience, and she's had a lot of leadership roles in the corporate realm. And she founded her own HR firm back in 2001. So she knows the challenges, the questions, all of the complexities that entrepreneurs face like the back of her hand. And her experiences have ignited a vision, one that envisioned accessible HR guidance and educational resources. And so the Leader's Journey experience was born. So that is an education program meticulously designed to equip entrepreneurs and business professionals with the tools, guidance, and confidence that they need to navigate the intricate world of HR, but in a much simpler way. Well, if you're an employer, maybe you're an employee or just someone who's kind of curious about what at-will employment is all about, you're in for a treat. So stick around. Let's dive in head first and learn all about at-will employment with my guest, Vicky Brown. All right, Jess Get Hired Podcast family. I'm excited to have with me, I have Vicky, who is the CEO and founder of Idomeneo. Did I say it correctly, Vicky?
You did, Idomeneo. That was perfect.
Awesome. Well, I'm excited for this conversation because I also have a lot of questions when it comes to at-will employment. And we're calling this episode Legal Loopholes and Labor Myths, At-Will Employment Unveiled. So are you ready for it?
All set.
All right. Well, maybe just to kick things off, maybe you can break down the common idea that bosses have about just waving goodbye to an employee for whatever reason they fancy, consequence-free.
Absolutely. And Jess, I just want to take a moment and say thank you so much for inviting me. I'm thrilled to be here today. So the thing that I hear most often from clients and actually just employers across the board is we're an at-will state. So I can hire or fire, I can fire anyone for any reason or no reason at all that I want to because we're at will. And I think that there are a lot of misconceptions around what at will really is. People understand part of it, but then they forget about the other half of it. So part of it certainly is that you can let someone go for any reason or no reason without giving them notice that you feel is appropriate. And by the same token, the employee can then leave your employ for any reason or no reason without giving any notice. That's the part that everybody understands. The piece that they don't understand is with that, there are still reasons that are illegal reasons for terminating someone. So, for instance, if it's a reason that can be tied to retaliation or discrimination or harassment, those are always illegal reasons for letting someone go. So even though you may be in an at-will state, there are guidelines that specify that you can't terminate a person for those kinds of reasons. And then on top of that, there is this lovely thing that most people don't know anything about called the covenant of good faith exception. Now, not every state is an at-will state. Many states are, but even more states have the covenant of good faith exception. It's a sweeping doctrine, and basically what it says is that you cannot terminate someone unless it's for good cause. Doesn't matter what your handbook says, doesn't matter what kind of policy or practice you have in place, you still can only terminate them for good cause. Otherwise, it's deemed an illegal termination. And good cause means that there's a valid, legitimate reason for letting them go, something related to their work performance or the position or company needs or a combination of those things. So it's not just, oh, Vicky wore a pink dress today, I don't like it, I'm going to terminate her.
Well, the whole changing the job rules on a whim sounds like a head scratcher. I mean, does that have anything to do with at will, or maybe can you give us the lowdown on why that's not as simple as it sounds?
Sure. That's the whole thing around sometimes when you get an offer letter, and I'll talk about offer letters versus employment agreements in just a second. But when you get an offer letter, it's probably going to say something like, very broadly speaking, the responsibilities for the job are X, Y, and Z, and other responsibilities as assigned. At least it should say that. At least all of my clients' offer letters say that.
Right.
And the reason it does is because the employer does reserve the right to alter your job description. They do have the ability to do that unless it's, in your agreement or something that they specifically cannot do that. As long as they're not asking you to do anything illegal or anything that will put you in danger or your colleagues in danger, then they can legitimately ask you to do another task. And as I said, most offer letters have kind of that wiggly language in it that says the employer has the opportunity to provide additional tasks to you. Now, having said that, if your job is marketing manager and your employer says, okay, I want you to handle the technology department. Well, no, those are very, very different skill sets. And so it's reasonable to think that you would not be successful in the second thing because that's not where your skill set lies. What that means is really if the employer needs a technology person and they don't need a marketing person, then they, from an employer standpoint, they need to think about what they really need in their organization and hiring somebody specifically for that job. And if they need, unfortunately, if they would need a technology person, if that's a more dire need than the marketing person, then maybe they'll end up, kind of downsizing the marketing job and hiring a tech person. So if they're getting wildly out of your sphere of experience or skill set, typically, I don't see that happening. Typically, that means that the employer is going to make some choices around how the workforce actually looks But the concept of I have the ability to do this other thing, or I need to do it for a temporary reason. Here's a good example. So I have an HR consulting company, and my HR business partners, their job is to be the HR contact for our clients. Now, sometimes we have a big benefits open enrollment. They tend to all cluster in December.
Right, they do.
And so we're trying to put together packages and make sure that everyone gets, logged into the system successfully and all of that. And that's all hands on deck. We all kind of chip in and we do whatever needs to be done. Is that strictly part of the responsibility of the HR business partner? Not on a day-to-day basis. It's probably really the responsibility of the associates underneath them, but we all do it, including me, by the way, the CEO. So that kind of thing, if a business partner said to me, oh, that's not my job, so I don't have to do that. Well, that would not be true, because I do have the ability to say, you know what, we all need to do this right now, and we're going to get it done.
So I have another question about debunking the immunity myth. And I think you touched on this earlier, but employers think that they're untouchable when it comes to, being in one of those at-will states. Can you break down any other misconceptions about that? What's the reality?
Yeah, absolutely. So the reality is, again, at will is not I'll probably date myself by saying this, but a get out of jail free card. That's very Monopoly, I think. But it's not a get out of jail free card. At will is certainly a concept that says the employer or the employee are not locked into a specific period of time that they have to be together. That's what an employment agreement does. So again, very often I will hear employers say, oh, I have a new hire. I want to go ahead and send them the new hire documents along with their employment agreement. Well, employment agreements generally fly in the face of at will. So at will, again, hire or fire. Fire for any reason, or terminate or resign for any reason, no notice. An employment agreement generally will lock you into a notice period, and in fact lock you into an employment period. And for that reason, and that sword kind of swings in both directions. So on the one hand, the employer is saying to the employee, I am requiring you to stay in this job for a year or 2 years, and then we'll renegotiate the employment agreement. The employee is saying, I'm going to do this, but that means you're going to pay me for a year. It's basically pay or play. You're going to pay me for a year or 2 years, the length of the contract. And if you try to get rid of me before the contract is done, there's a financial penalty in place for you. Maybe you have to pay out the remainder of the contract. Maybe there's an actual penalty amount that's written into the contract. In any event, it's going to have some pain on the employer's side if you let me go before the contract is done. Because employment agreements really do lock you into working together for a period of time. Generally speaking, and I'm not an attorney, I always refer everyone counsel, and I'm doing so now, but generally speaking, you probably want to reserve employment agreements for the senior team members on your team. So the C-suite folks, maybe you have a fantastic technology person and you can't run without them. So you want to make sure you're not going to come in one day and get a 2-week notice from them that they're leaving. You want to make sure that you have them in place for a year or 2 years or 3 years or whatever the case may be. Everyone else, though, really should receive offer letters versus employment agreements. Because like I said, employment agreements do kind of lock you into a time period. An offer letter, on the other hand, is just a confirmation of the terms of the employment. We've offered you the marketing manager job. You've agreed to take it. You're going to have these responsibilities along with others as may be assigned. Your salary is going to be this. You're going to report to that person, et cetera, et cetera. So it's not signed and countersigned, and it's not a legally binding agreement. It actually is just a letter of confirmation, which is very different from an employment agreement. So that's one thing that employers have to be careful about. If you don't have an employment agreement with your folks, if you really are dealing with an offer letter, again, at will is not a free ticket. You still have to be careful about the reasons that you're letting someone go. And you not only have to be careful about it, but you have to document that. I mean, I know that a lot of times we hear from employers, we're in at-will state, why is my HR person or why is my employment attorney asking me to write all this information down or give a warning or have a conversation, have the employee countersign it and all those kinds of things. Well, there are lots of reasons for that. One is from a human standpoint, you should really let someone know if they're not doing a great job, because the goal is to help them improve. You want them to do a better job, and you want to help them do that. The goal is not, let me write down all of this information so I have backup documentation to terminate someone. That's not the purpose of a warning process. The purpose of a warning process is really it's a call out. It's a call out to the employee. This is really a significant issue. We need to resolve this issue together. Let's talk about how we're going to do that. And there's a certain time frame that I'm looking for improvement. So that's really the purpose of a warning process. Now, the other side of it is, of course, it provides you with legal documentation if, unfortunately, you do get to the point where you're letting the person go. So it's important to go through that process and to be very clear about what your expectations are, where the person is not meeting the expectations, and what the possible outcome will be if you don't see the kind of improvement that you're looking for. So, just kind of willy-nilly, I can just walk in and fire someone this particular day. You can, but you're probably going to hear from their attorney later on. Because even if you don't think, right, exactly. Even if you don't think that you've done anything that is untoward, the person may come back and say, I feel like I was discriminated against and for this reason. And if you don't have solid documentation behind you that says, no, the reason you were terminated is because of that reason, then you may find yourself trying to defend your position.
Right. Well, I definitely tell all of our managers that you have to have a paper trail. Always CYA.
Exactly.
Especially nowadays, like you said, everybody is out to find the loopholes within your employment agreement or, whatever you're writing them up for. So, it's really important just to document everything. That's what I tell everybody.
Absolutely.
So now I heard there's a thing about employers are responsible or can be held responsible for employees' actions outside of work. Is that true? And if so, are there any examples that you can help to illustrate that?
Sure, absolutely. Well, generally, that can be surprising to people because generally speaking, particularly I'm in California, and California is very specific around what you do with your own time is your own business. And as an employer, I cannot get into it or tell you what to do, right up to the point of having another job. Moonlighting in California is not illegal. So I really can't delve into your personal life. But where that does not hold true, and this is true in many, many, many states across the nation, where that does not hold true is if the individual, the employee, is acting in the course and scope of their employment. So there are a couple of examples. One is, let's say you have a pizza delivery service and they say that they guarantee that they're going to get you your pizza within 30 minutes. And a delivery driver in the course of delivering that pizza hits a pedestrian. So the employer can be held responsible for that because it's part of the company policy. That's one of the KPIs really that the company has.
Right.
And so the delivery driver in the course and scope of their job hit the pedestrian. Another one, and this is one that is really interesting, is many years ago, but a salesperson was off work technically, and they were on their cell phone talking about their next meeting or whatever the case may be, and they were driving at the time. Unfortunately, there was an accident. Someone was severely injured. As a matter of fact, unfortunately, I think someone lost their life. And they backed it up In the court case, it was back all the way up to the employer because the employer was responsible for, it was a company cell phone. The individual was acting
Wow.
within the scope of their business, of their work. So again, that particular case has resulted in some language that we always insist go in the handbook for our clients, and that is around adhering to all driving laws and cell phone laws, et cetera, et cetera. You don't want people texting and driving. You don't want people on their phone and being distracted and driving, because if something happens, you as the employer can be held responsible for those things. So
Wow.
again, if someone is at work or not at work, if they're acting within the scope of their job, they're doing some sort of work function, then yes, the employer can be held liable.
Wow. Well, that's an eye opener for me. I did not realize that. So thank you for sharing that example with us.
Sure.
Now, you mentioned earlier the crucial role of legal professionals. If you have any questions, consult a legal professional because we don't want to give the wrong advice. But, and I know California is totally different than most states. You consult businesses all across the nation, right?
Absolutely. Yes, we do. We do. And California certainly can be a leading voice, shall we say, in some of the employment legislation. But I have to say, there are plenty of states who are close on our heels. New York has, as a matter of fact, New York is out in the forefront around managing and putting regulations around things like artificial intelligence, the use of that in staffing and things like that. So just because you're not in California does not necessarily mean that you have all the flexibility in the world.
That is true. Well, what's one golden nugget of advice that you'd give employers to keep in mind when navigating through this terrain that we have of at-will employment and just some of the other legal things that happen within, someone's employment terms?
Sure. There are two big pieces. I mean, broadly speaking, all sorts of things I can say that will get us into the weeds of HR, but there are two broad pieces of advice that I can give. One is make sure that everyone is retaining their dignity. If you really think of it from that perspective, not, oh, I have this employee who isn't performing, oh, I need to get rid of that person, they're really getting on my nerves, whatever the case may be. If you just remember, let's let everyone retain their dignity. If someone's not meeting the expectations of the job, then that's the issue. You want to attack the issue, not the person, because someone who isn't living up to your expectations for your position might be an exceptional employee for the job across the street with another company. They may just be the wrong fit. So again, you don't want to surprise someone with a termination. That's another reason for going through the warning process. When you're trying to resolve issues, you want to go after the issue and not the person. It's not you're lazy. It's that how can we help you be more engaged and turn in your assignments on time and make sure that you're proactive and those kinds of things. So that's one huge piece of advice that I give people. The other is what we were talking about. You absolutely, I can't wade through accounting guidelines. I don't know beans about accounting. I know enough to be dangerous.
Neither do I.
But that is not my superpower. So I rely very heavily on my accountant. And I think that anyone who's dealing with employees or dealing with team members, you really need to make sure that you have some sort of expert support behind you. So engage a really good labor attorney. You don't have to talk to them all the time about absolutely everything, but there will be critical times where you will really need some valuable, experienced legal knowledge behind you, and that's where you're going to get it. We can all, you can certainly Google the answer, but that doesn't mean that it's right for your particular situation. because HR is always so nuanced because human beings are nuanced. And that's really the business of HR is, it's in the name, human. So that's, Googling the answer may not get you the answer that you need or even the answer that's right for your particular situation. So always have the number of really solid labor counsel in your back pocket.
I agree because, I help a lot of small to medium-sized businesses that, are just starting out and they don't have, a dedicated HR person, or they try to create rules as they go, or they don't like something. They just say, I don't like that. So we're going to create a policy around that. And that is what it's going to be. And obviously, that doesn't hold very well in court whenever that happens. And I know a lot of people use Google for, to check their ailments and Dr. Google, but Google is not your Google and Google attorneys at law. It is definitely important to have someone like you also to help consult, but also to have legal counsel available for anything that might come up. But Vicky, before we sign off, I want to hear what's coming up on the horizon with Idomeneo. What type of endeavors are you working on? Anything you want to promote or share with our audience?
Absolutely. Well, thank you so much for the opportunity. We actually have a little special gift for the listeners. So, and we can put this information in the show notes as well.
Okay.
But we have a guide to, specific HR situations that come up, kind of how do I go about putting together a new hire package or a termination package, as the case may be. And you can get that at morehuman.info/podcast gift. So we're making that available to all of your listeners. And we are here to help in any way that we can. As I said, it's important to have labor counsel, certainly. And I think one of the best things about Idomeneo is we know when to tell you to call counsel, and it's always earlier than you think. And certainly be that interim and tell you what is, what might be an issue that you want to keep an eye on, and also what general practice is, because obviously we deal with these issues every day. So again, that's morehuman.info/podcast gift. And we'd be thrilled to help in any way that we can.
Awesome. Well, I will definitely put that into the show notes so that people can find that. Who doesn't love a free giveaway, right?
Exactly.
Thank you for your hot take here on legal loopholes and labor myths. So hopefully anyone who's listening, if you have questions, you can also reach out to Vicky. Remember all of the things that you've learned here and all of the ins and outs of at-will employment. That's the key ingredient to creating a fair and compliant work environment. So I hope that everyone found today's discussion very helpful. Make sure that you subscribe to the Jess Get Hired podcast. Go find Vicky. We'll put all of the links to find her and learn more about her business. But Vicky, thank you so much for being a part of the Jess Get Hired podcast.
Oh, thank you so much again. I've had a great time.
I want to say thanks again to Vicky for being a part of the Jess Get Hired podcast. And I want to thank you for tuning into the show. If you like my content, don't forget, hit that subscribe button, head over to my website, jessgethired.com. You can connect with me, follow me, network with me on LinkedIn, search my full name, Jessica Fiesta George. If you're on Instagram, I would really appreciate it if you go follow my page, Jess Get Hired. I'll follow you back. I'll make sure that I add all of the links to find me in the show notes. And if you want to connect with Vicky, I'm going to make sure I add that in there as well. But if you go to my website, I have all of the information about any guest who's been on my show. And that way you can follow them and find them as well. Well, my name is Jessica Fiesta George, your host of the Jess Get Hired podcast. What do y'all want to talk about next? I'll catch you on my next episode.